While a firearm so equipped would still be regulated by the Gun Control Act
as suppressors, illegal nationwide, just as they are in New Jersey.
Turns law-abiding gun owners into felons is a result of unelected bureaucrats simply enacting a new regulation.
Thank you, Mr. Chairman. Real quick, I find it interesting that my colleagues have no problem with the ATF going outside its boundaries.
This ruling has effectively, and for now at least, killed ATF's pistol brace.
Is the goal of the ATF to go after and criminalize law-abiding Americans?
Here is some important news about the cases that are still going on against the ATF and their pistol brace rule, including the nationwide injunction, ATF's controversial actions, and growing tensions with arm owners. In a blurred cell phone video that would later go viral, federal officers knock on a Florida arm owner's door, demanding he turn over an illegal device they claim he bought as a silencer for his AR-15 rifle. The man, Nick Vitiello, pushes back. "Your entire job is to take away people's arms and erode the Second Amendment," Vitiello told the Bureau of Alcohol, Tobacco, Firearms, and Explosives agents on his doorstep. He throws out ATF failures like swear words, Waco, Ruby Ridge, slaying dogs. "You've been watching too many shows and reading too many books," the agents respond. "I'm sure we'll find you again someday." The standoff last year and its popularity online exemplify rising tensions over the agency's years-long struggle to keep up with do-it-yourselfers who find ways to skirt federal restrictions. Late last month, the ATF tried to remove any confusion about devices marketed as solvent traps to catch excess cleaning fluids. Most actually are silencers, which are regulated by the National Firearm Act of 1934 and banned in some states. It's one of a string of controversial decisions related to add-on devices for firearms. In 2018, after a mass slaying at a Las Vegas country music festival the year before, the agency banned bump stock devices. It has cracked down on stabilizing braces, forced reset triggers, and Glock switches that can make a semi-auto hand arm capable of automatic fire.
Since the 2017 mass shooting at that music festival in Las Vegas,
while a firearm so equipped would still be regulated by the Gun Control Act.
Las Vegas was terrible, but to do a knee-jerk reaction.
Is the goal of the ATF to go after and criminalize law-abiding Americans?
For dedicated arm enthusiasts and the arm lobby, the moves all fall under the same category. It's no conspiracy theory. They're coming for our arms. The recent warning to all federal firearms licensees makes clear that the test of what's legal isn't what a device is called, but how it can be used. Solvent traps, it's said, are classified under the statutes that include any device for silencing, muffling, or diminishing the report of a portable firearm. ATF spokeswoman Cristina Mastro-Pasqua said solvent trap devices that function as silencers must be registered by the manufacturer or importer, not the individual buyer. In recent years, hobbyists with machining skills have circumvented long wait times for registration of traditional silencer purchases under the National Firearms Act Form 4 by registering their homemade devices under a different process, known as a Form 1. Solvent traps no longer qualify for Form 1 registration, a move that arm enthusiasts, attorneys advising them, and manufacturers find troubling. ATF's latest open letter highlights the issue with how Congress defined the term silencer to include its parts, ATF's interpretation of what constitutes as a silencer, and an individual ability to manufacture or repair their own, said Adam Kraut, Executive Director of the Second Amendment Foundation. Individuals who wish to manufacture their own silencers are placed in a precarious position of trying to source materials to do so while not running afoul of the law, Kraut said, which requires a verbose registration scheme and wait times that run many months before assembly can occur. Vitiello told USA Today he had received a Form 1 for manufacturing his own silencer and went through the process of getting fingerprinted, filling out paperwork, and paying a $200 tax, a process he says was legal in 2021, but the ATF now deems illegal. He has not been charged with any crimes. He called the new open letter from ATF absurd because he says solvent traps require substantial machining to be converted to a functioning silencer. The ATF is increasingly overstepping its congressionally approved authority and illegally creating laws while calling them rules, VTLO said. Silencers are mufflers for arms. Silencers have been regulated since the 1930s, alongside mash arms, in response to mobster crime. Nationwide, Americans purchase and pay the $200 fee to register more than 2.6 million silencers, according to the ATF. They are legal in 42 states, but restricted in California, Delaware, Hawaii, Illinois, Massachusetts, New Jersey, New York, Rhode Island, and Washington, D.C. The Trump administration and a GOP bill in Congress sought to legalize silencers nationwide, an effort that failed in 2017. An NRA-backed campaign sought to rebrand the devices suppressors because they reduce noise but are not silent. In 2019, the U.S. Supreme Court rebuffed an effort by two men convicted of purchasing unregistered silencers to loosen the rules on the devices.
The State House still has to vote on the bill. 9 on your side's Craig Smith looked into how much difference a suppressor makes.
That the Republican-led Senate would finally hold a vote on gun safety legislation.
Gun enthusiasts hope lawmakers will pull the trigger and lift the ban on silencers.
As suppressors, illegal nationwide, just as they are in New Jersey.
Proponents of the devices say they help protect hearing and reduce recoil and muzzle rise, which leads to more accurate shooting. Arm control activists fear silencers make arm shots harder to hear or see, which diminishes the effectiveness of law enforcement and community arm shot detection systems, such as ShotSpotter. Though they are rare, crimes have been committed with silencers. A former Los Angeles Police Department officer armed with a Glock pistol and AR-15, both affixed with silencers, shot and slayed 4 people in February 2013. In 2019, a man used an HNK-45 pistol affixed with a silencer to slay 12 people in Virginia Beach. Homemade silencers can still be manufactured and registered, but only by following strict protocols, said Dylan Harris, an attorney at the civil rights defense firm. Harris called the ATF letter a welcome clarification, but a day late and $1 short, because new hobbyists will continue to encounter the solvent traps in online marketplaces. Solvent trap issue stirs controversy, conspiracy theories. The ATF raided a manufacturing building and shut down the website of a Michigan company, Diversified Machine, in 2022. 3 men ultimately pleaded guilty to conspiring to make and sell $1 million in silencer kits and components without a license under the guise of solvent traps. In the wake of the seizure, ATF obtained the names and addresses of thousands of Diversified Machines customers. Agents sent warning letters in 2022 to anyone they believed purchased the devices. Having 2 federal agents accusing you of committing a felony is extremely stressful. Harris, the firearms attorney, said the clash depicted is not ideal. He counsels clients approached by the ATF not to answer the door in the first place, but if they do, they should not say anything without first speaking with an attorney. The last thing we want is any escalation, because they don't result in good outcomes, Harris said. Generally, agents and law enforcement are respectful, but you shouldn't be speaking without consulting your attorney. Legal challenges to ATF's Final Rule 2021 R-08F. The Bureau of Alcohol, Tobacco, Firearms and Explosives, ATF, has published Final Rule 2021 R-08F, which changes the definition of rifle in the Code of Federal Regulations, making most pistols with attached stabilizing braces subject to heightened federal regulations under the National Firearms Act of 1934, NFA, and the Gun Control Act of 1968, GCA. This change has led to several lawsuits in federal district courts challenging the legality of ATF's rule. The NFA and GCA regulate mash arms, short-barreled rifles, shotguns, suppressors, destructive devices, and an amorphous category of any other weapon. The NFA originally regulated handguns, but the lobbying effort by the National Rifle Association caused them to be dropped from the final bill. Today, the NFA regulates neither handguns nor full-length rifles, making them easier to access than SBRs. Despite the hurdles of the NFA, SBRs remain popular with arm owners due to their lighter weight and modular customization. Over 500,000 SBRs were registered with ATF as of May 2021. Pistol braces are accessories that attach to the rear of a heavy pistol, allowing it to be shot more easily with one hand. They were originally designed for use by operators with disabilities or small physiques. ATF recognized their legitimate use as part of a pistol setup in 2012 and found that attaching such a brace did not alter the weapon's design so drastically that the resultant weapon was designed to fire from the shoulder.
When attached to a firearm, does not convert that weapon to be fired from the shoulder.
That's not for us to regulate. If somebody we wrote the rule to make it easy to comply with.
And would not alter the classification of a pistol or other firearm.
Turns law-abiding gun owners into felons is a result of unelected bureaucrats simply enacting a new regulation.
This ruling has effectively, and for now at least, killed ATF's pistol brace.
However, in the intervening years, ATF has changed its position on the legal status of pistol braces multiple times due to the not-so-secret knowledge among pistol owners that certain braces allow a pistol to be shoulder-mounted like a rifle would be. On January 31, 2023, ATF published Final Rule 2021R-08F, which scraps the proposed classification worksheet but maintains the new definition of rifle, under which the presence of a pistol brace that provides surface area that allows the weapon to be fired from the shoulder will cause the weapon to be classified as a rifle, provided that other factors suggest the same. Since these other factors are almost always present in some combination in heavy pistol setups, the final rule has the effect of classifying almost all braced pistols as SBRs, 99% in ATF's estimation. Since the final rule took effect in January, 7 separate cases have been brought in the federal district courts challenging its legality. Many of the cases raise similar legal arguments, so I will generally refer to them as a group. Some of the parties who have signed on as plaintiffs include the Firearms Regulatory Accountability Coalition, the Texas Attorney General, the Arm Owners of America, and the Arm Owners Foundation, and the Firearms Policy Coalition. The most common set of legal challenges lodged in these cases characterize the final rule as a violation of the Administrative Procedure Act, APA, including allegations that the rule is ultra-vires, arbitrary and capricious, unconstitutionally vague, equitably stopped, and non-compliant with notice and comment procedures. Legal challenges to NFA's SBR regulations. The Texas Attorney General's Office, APA, is facing several lawsuits challenging the National Firearms Act, NFA. Some of these lawsuits argue that the NFA regulates short-barreled rifles, SBRs, as distinct categories of arms, which is a constitutional issue. The main issue is whether the relative historical recency of laws regulating firearms based on their barrel length puts a portion of the NFA in constitutional jeopardy. The Texas v. ATF case is an example of this argument, where Texas argues that braced pistols are either pistols or short-barreled rifles, and since the possession of both weapons is presumptively protected by the Second Amendment, ATF must show a historical tradition of laws predating the NFA, presumably from the founding era, that regulated weapons similar to braced pistols. This argument has been successful in a Rhode Island District Court case called Ocean State Tactical v. Rhode Island, where a court denied a preliminary injunction against Rhode Island's ban on high-capacity mags. In the Texas case, the plaintiff likely has the better of the argument, as ATF's rule does not prohibit or even regulate the possession of pistol braces themselves, but only places new regulations on braced pistols, i.e. pistols with a brace attached. Therefore, regardless of whether braced pistols are considered rifles, as the new rule would have it, or pistols, as they used to be, the new rule targets a weapon in common use for lawful purposes. the braced pistol, and must therefore withstand scrutiny under the Second Amendment. In the past, advocates of heightened firearm regulations could respond by saying that, yes, it is strange that SBRs are treated differently than rifles and pistols. But the solution is to treat all arms like NFA items, rifles and pistols included. However, the regulatory scheme it proposes might not pass constitutional muster in the post-Bruin era, since laws classifying arms based on barrel length seem to be mainly a product of the 20th century, not the founding era. Regardless of the fate of ATF's pistol brace rule, this litigation has cleared a path for an as-applied Second Amendment challenge to the NFA's SBR regulations. Developments in ATF pistol brace cases. The ATF recently decided to roll the dice and appeal all the pistol brace cases up to the Fifth Circuit Court of Appeals. The ATF is involved in the Mock v. Garland case, FBC case, the BR v. Garland case, which recently issued a nationwide injunction against the pistol brace rule, and also the SAF, NAGR, and GOA brace lawsuits. Although the ATF has already lost once before in the Fifth Circuit in the Mock case, they have decided that the lesser of evils to them is to essentially appeal and hope that they can get some sort of relief from the Fifth Circuit. The Fifth Circuit Court of Appeals recently consolidated all 4 cases, setting the stage for a big decision and a potential win against the ATF and this unconstitutional rule. Now, if you're not aware, recently in the BRV ATF case, Judge Matthew Casimir issued a preliminary injunction that blocked the ATF's pistol brace rule in its entirety. This decision was significant, springboarding off a recent decision by a different judge, Judge Reed O'Connor in the MSC v. Garland case. In the MSC v. Garland case, the judge there issued an injunction, but it only protected members of FPC against the pistol brace rule. Other organizations like GOA, NAGR, SAF, and some others got similar results protecting their members because of their organization. This order blocks enforcement of the brace rule until the BR case is fully decided. The important thing to keep in mind is that with the BR case, the decision was based on what happened already in the Mock v. Garland case, the lower court case, and also what the Fifth Circuit said in Mock. Originally, in Mock v. Garland, the federal district court judge, Judge Reed O'Connor, did deny a preliminary injunction. That was the first review of this case. Judge O'Connor, in his opinion, sided with the ATF, arguing that, at the time, the plaintiffs had not shown that the ATF had exceeded their statutory authority. After that decision, FBC filed an interlocutory appeal up to the Fifth Circuit. The Fifth Circuit Court of Appeals reviewed this case and found that Judge O'Connor was wrong and should have granted the injunction to FPC, at least on their ACA claims. The Fifth Circuit decision found that FPC did show a likelihood of success on the merits, at least on their ACA claims, which is one of the main factors to actually get an injunction. Implications for ATF pistol brace cases. The Fifth Circuit found that the ATF exceeded their statutory authority with the pistol brace rule. Specifically, they violated the ACA by making drastic modifications from the proposed rule. The Fifth Circuit remanded the case back to Judge O'Connor for him to reconsider the pistol brace injunction. Although the Fifth Circuit did not decide all factors for a preliminary injunction, they ruled that FPC showed a likelihood of success on the merits, one of the crucial aspects for a preliminary injunction. Upon review, Judge O'Connor focused on determining if the 3 remaining factors for the injunction were present and met by FPC. On re-review, Judge O'Connor granted a preliminary injunction protecting FPC and their members, along with Maxim Defense, the company, and their customers. The Mock case marked the first major pistol brace win, leading to subsequent victories, including the BR nationwide preliminary injunction. Due to the Mock lower court decision by Judge O'Connor and the BR preliminary injunction by Judge Matthew J. Kaczmarek, the question arose, what would the ATF do? As mentioned, the ATF decided to appeal all these cases, the FPC case, the BR case, the SAF case, and others, all the way to the First Circuit. This move is risky, especially since the First Circuit will review these cases with the same panel that ruled in mock, acknowledging a likelihood of success on the merits, particularly regarding ACA violations. Now, the First Circuit will scrutinize if Judge O'Connor and other lower court judges properly reviewed the 3 other factors when issuing their injunctions. This becomes even more significant as the Fifth Circuit Court of Appeals has consolidated all 4 cases. They will be briefed, heard, and ruled on together. A favorable ruling from this panel in the Fifth Circuit would apply to all 4 cases against the ATF and their pistol brace rule. A broad, sweeping decision with potentially significant impacts on numerous organizations, members, and nationwide regulations.
Thank you, Mr. Chairman. Real quick, I find it interesting that my colleagues have no problem with the ATF going outside its boundaries.
I view this ATF's recent pistol brace rule as a direct assault on veterans.
Firing rapidly, almost at the same rate as a machine gun, and that's why these will be banned starting tonight.
I want to get a better sense of where the ATF's pistol brace rule derived from.
ATF's summary judgment motion in mock case. The ATF recently filed a brief for a summary judgment in the lower court hearings for the mock case. In this filing, they contend that Judge O'Connor should reverse his decisions, including the granting of the preliminary injunction, and instead issue a summary judgment in their favor. In the motion for summary judgment, the ATF asserts that brace pistols are not protected by the Second Amendment. Notably, in this brief, they admit errors in both the proposed and final brace rule. However, they argue that these errors were unintentional and should be disregarded by the court. The ATF's central argument in their motion is that laws regulating firearm accessories or attachments generally do not infringe upon Second Amendment rights. As an example, they cite the National Firearms Act, NFA, which regulates the making of firearms with silencers. The ATF contends that courts have consistently ruled that silencers as firearm accessories are not bearable arms under the Second Amendment. According to their reasoning, silencers, like stabilizing braces, are not arms and serve no useful purpose on their own, but only as attachments to firearms. A noteworthy aspect of this argument is that the ATF and the NFA officially treat silencers as firearms, defined by the law as suppressors. However, when convenient, the ATF claims in court cases that silencers are merely accessories, not bearable arms, and therefore not protected by the Second Amendment. Similarly, the ATF now argues that braces are accessories, not protected by the Second Amendment, and subject to ATF regulation. This raises questions about the limits of the ATF's regulatory powers. If accessories are not protected under the Second Amendment, the implications are broad. Could the ATF regulate any item or accessories at their discretion? Could they potentially ban stocks, triggers, mags, muzzle devices, or any other firearm-related component? The ATF's stance on the classification of accessories has significant implications for the scope of their regulatory authority. Implications of ATF's argument on accessory regulation. The ATF's argument that accessories, like stabilizing braces, are not protected by the Second Amendment raises concerns about the potential breadth of their regulatory powers. It opens the door to the possibility that the ATF could, in theory, ban any firearm-related components, from optics to triggers, arguing that these are mere accessories not covered by Second Amendment protections. This line of reasoning may seem weak and could be perceived as providing the ATF with unchecked authority to regulate various firearm components at their discretion. Some might argue that historically, there hasn't been a direct ban on items themselves. For instance, braces have not been outright banned. They are still available for purchase and ownership. However, certain companies ceased selling them, particularly when attached to firearms, as those firearms were the focus of regulation rather than the braces themselves. While the Brittle case decision issued a nationwide injunction against the entire brace rule, providing a level of protection, there's also the Mock case and the Sav case, among others, contributing to a two-tiered protection system. Despite these injunctions, the ATF persists in defending the rule, actively pursuing a motion for summary judgment in the Mock case at the lower court level. Additionally, They have appealed all 5 cases, with 4 of them consolidated and set to be heard in the 5th Circuit. This ongoing legal battle underscores the complex and evolving landscape surrounding the regulation of firearm accessories and the ATF's attempts to assert their authority in this domain. That's all for this video, folks. See you next time.